the power of administration to another brother or sister. Now what do you do? He was in total chaos. The letters prove that the seller is the official representative of the estate. And this is what's going to tell you exactly. So we're going to jump forward to the form, the letters. And in here, this is what you have to have a copy of. And it tells you the estate. And right there, number one I put is exactly the way you have to take the listing. You don't take it as Mr. John and Mary Hernandez. You take it as what is put in this box, the estate of John and Mary Hernandez. I've seen 5 or 6 different names in that account because the mom or the dad may have been married before, and there's the estate of John Hernandez and Maria Hernandez, but Maria was married before and she was called Maria Smith, and then she had a third husband, Mary Doe. And the way the court puts in that box is exactly the way you have to put it on your listing. We just did one where there was 9 names on there, and the probate court is making sure that everybody's notified, that maybe an ex-husband or a daughter from an ex-marriage is notified. So you must put exactly the way it is in the estate of in that box. The other thing is it appoints, number 2, it appoints who is the administrator. In the case of my friend, he took the son who said he was going to be handling everything, only for, for some reason 2 or 3 brothers and sisters protested and they gave it to presumably the daughter. So this is exactly the court appoints, and number 2, who is going to be signing. And then down the road, we'll go into when you start signing the probate listing and the representative capacity, that's who's going to be signing exactly what it is. Then it also tells you the most important thing, number 3, full authority or limited authority. And we'll go into that. If it's full authority, it's almost like a standard sale. There's a couple things that are a little bit different, but for most part, you don't have to go to court. The brother and sister, or maybe a single child inheriting the house, there's nobody going to contest it, or it's very amicable. However, sometimes families aren't too amicable, and now the court gives limited authority, and we'll go into that. And that's when you have 2 or 3 brothers who are fighting, they don't trust each other, or there may be other heirs who want to know exactly what's going on and sell it for the top dollar. We'll go into that in a second, because these are the 2 most important things. Another thing you should note up here is it's been filed. It was filed with the court with the stamp to make sure that it's legally executed. And also the case number is very important for you, because all counties have a probate division, and you can actually monitor and follow what's going on with your probate through this case number. So that's something that's very important. And that's pretty much the most important thing you're going to need for our compliance. When we close a file, we ask you for the listing, but we also ask you for the letters, because we, as an office, must make sure that person had the right to sell the home. So as we continue, we now go into full authority or limited authority. Now, under full authority, it's been granted the letters. It basically allows the personal representative to do almost anything they want without court approval. You got just a single person, or the brother and sister get along, and the brother says, I closed one where the brother said, look, I don't know, sister, you're the brains of the family, you deal everything, I believe everything you say. And it's almost like a standard transaction, other than the attorney has to file some paperwork. In most cases, like I said, if you have a benefit, a very comfortable, you have to sign a form of a proposed action. Now, in some cases, the form can be waived, and that's called, a waiver of the proposed action. Because normally if somebody challenges it or there's a question, you have to send out a notice of proposed action telling the heirs what you're doing, how much you're selling the house for, And if everybody's amicable, it takes 15 days. If everybody doesn't even want to go that far, you can get a waiver of the proposed action, especially if you're trying to close fast. Now, in probate, you can sell the home. Probate's taken anywhere from 9 to 12 months. You can sell a home, and then all the money is put into probate. And then 6, 7 months after you've closed, the money is dispersed to the heirs. So we're not attorneys. We can't sell the house and give people the money. Escrow must put it into a probate account. Normal cases, you can get the proposed action waived. However, if there's a brother or somebody that is questionable, then they have to do what's notice of proposed action, and we'll go into that exhibit real quick. It's basically, if they contest, then it turns it into a limited authority. So basically, a standard PR can take care of it normally, but if somebody contests it, and we'll go into why they wouldn't in a little bit. A couple of notes. Probates can't be longer than 90 days. I see this all the time where agents take a listing for 180 or a year. The courts don't allow that. They want to make sure that you're on top of your game and you're doing what's supposed to be done. And so for that reason, they only allow 90-day listings. You can get an extension from the representative, or if you haven't sold a house in 270 days, they will now petition the court and ask what's going on. In a standard full authority, you can get up to 6% commission. And so here we go. This is standard full authority. If there's a proposed action, it's sent to the other brothers or heirs, and they're telling everybody, hey, this is under my full authority act. We've sold the property for this much money, and if you're happy with it, sign it. If somebody says, no, I'm objecting to that. Hypothetically, the brother who said you can handle everything thinks the house is worth $1 million. Now all of a sudden he gets a proposed action saying we're selling it for $800,000 because grandma hasn't done anything in over a year or 10 years and the house needs fixing and this and that. At that point, the brother can say, no, I want it to go to overbidding in court, and I want to see, we want to get the top dollar for this house. Somehow this doesn't sound right to me. And now he objects, and that throws your listing into a, he'll sign here where it says the proposed action, and now that throws it into the court and is treated the same as limited authority, where you have to go and get court approval. In limited authority, the PR has limited authority. That's what it's telling you, that the process of going and selling his home has to be gone through the court. This happens a lot when you have contested probates. You know, you have a daughter or brother, they don't trust each other, or you have a stepchild or somebody who's looking on the sidelines and say, we don't want so-and-so to handle everything. We want this to go to the courts. We want an appraisal referee to value the property, and then the property must be sold for no less than 90% of that appraised property value. So it gets very involved in court. The limited authority also allows overbidding. You know, once you've got a listing and you've received an offer and it's limited authority, you now have to do a whole bunch of different stuff. And this is where the attorney posts 3 times over a period of not less than 10 days before the sale. And the third time, not at least 5 days after the first. So you can publish it fast, but it must be published. And that's letting everybody know that, hey, we're selling this house for $800,000 in an area that's worth $1 million. So now you get a lot of people, investors, who follow these limited sale postings, and they show up at the court, and they can, you know, take your, if you're representing the buyer, they can overbid and take the buyer out of the game and put their investor in there. So basically, it attends a court hearing. You have to publish it. Also, the agent who has the listing must publish in the private remarks the date and time of the overbid. So that's something I'll add in the next draft, but make sure that as a listing agent, you have to put in the court date, time, and the overbid. the minimum bid. So in limited authority, setting the a price can be tricky because you're an agent and you do your CMA and you say, hey, it should be worth $1 million, but it then goes to a court-appointed appraiser referee, and he values the property to make sure, since other people don't trust you, that it's, or trust the PR, that it's in that price range of, if it's worth $1 million, he'll value it at $1 million, and it can't sell for less than 90% of that. So this is where in limited authority, you start getting people not trusting each other, and hey, I want a referee to tell me what it's worth, and why are you selling mom's, I thought, $1 million home for $800,000? Now the court says, no, you can't sell it for $800,000. The lowest you can sell it for is $900,000, and that's where it gets a little tricky, in that you're losing control on your probate price. But that's the bottom line, is people aren't trusting each other. That's why you have limited authority. When it does go to court, there's limits on who can bid. And another very important thing is, if you're a buyer for probate, you want to make sure and call the attorney and or the listing agent and say, who do I need to make a cashier's check out to be qualified for overbid? A lot of people make a cashier's check made out to, what did I say, the estate of, that's on title, but that's not who's selling the property. Now it's the estate of what's on this probate form, and that cashier's check must be made out to them. So there's something you have to really pay attention to, and make sure you call the attorney to find out the exact way the cashier's check needs to be written to be able to bid in the court. There's a couple of rules on it. The overbid rule is 10% of the first 10,000, and then 5% minus the 10,000 on the rest. Here's an easier way to remember. It's 105% plus 500. That's the rule. Remember that one. It's just a lot easier to qualify in your mind what your overbid is going to be. Here's a note. Even though a limited authority is a lot more work, you ended up going to court, they put a limit on it of only 5% commission in LA and San Diego, and standard in 5% in other counties. And that's kind of a bummer, because you can get 6% on full authority, but they'll only allow you 5%. So a lot of agents get caught in that. Also on limited, when you go, and if it's limited authority, you must put in your private remarks that the minimum deposit must be 10%. And that's so that the courts know you're serious, and they won't set a court date. There's a form, and you've removed all your contingencies. In other words, when you go to court, if nobody overbids, it's yours. All contingencies are removed. You have your loan in place or all cash. And remember, all probates are sold as is. So that's why they make sure that all contingencies have been removed. And then once again, I reemphasize, probate listings can't be longer than 90 days. Extensions are allowed, but you must petition it. When you're with a limited authority, you better be very close to that attorney. You know, don't be talking to the seller, because the seller is hearing from the attorney what's going on, and you may lose some translation and that they don't understand. So when you're in a limited authority listing, you make sure you're talking directly to the attorney. If you're making an offer on limited, is you're purchasing it, make sure you tell that buyer, because they will get very upset that you're going to be tying up a 10% deposit. And sometimes you won't get into court for 4 to 6 weeks. And then you have somebody overbid you. That buyer is very upset that he tied up his money for 6 to 8 weeks and didn't get the property. So these are the forms that we'll go into in a second. Just make sure you're telling them this is a limited authority. We must go to court. You must have an open court proceeding with a 10%, and you may lose in overbid. So basically, Paul Horn's class, I can't tell you how enough. And if you really want to dig into probate, he tells you the court filing fees and the inventory and all that. That class is worth 10 times what the $99 if you're a CAR member and then you can actually get a CAR certified probate, and you can put it on your card. He also offers lead sources to where you can sign up for his probate leads, and his site, when I was on it 4 or 5 years ago, it would only provide names and this and that. Now he's providing the attorneys' names and email, so you can start doing a marketing blast to all of the probate attorneys. He also lists names, phone numbers, and emails for the beneficiaries and the representatives. He's not the only one out there doing that. There's also a probate data service. I took that course also. I take every course I can find, the CRs, because I've actually had an investor group when we were buying at the courthouses, and I was chasing a lot of probates as a marketing campaign. So there's something you can do. Basically, the CR has changed. Before, you used to have specific probate listing agreements and specific probate purchase agreements, and they've gone away with that, and now you can use a standard listing agreement. Make sure you get the letters, make sure everything's done legally, and now you put in this probate listing addendum, and it's called a PLA. And once again, it goes through, it makes sure that you get the information that this property is part of a probate. If it's conservatorship or guardianship, that's a whole different talk. You know, that's when you got people who are still alive and you need a conservatorship. A lot of times things get blown up because the son says, or daughter says, my father's, incapacitated, I have power of attorney. And what I failed to mention, at the very top of the form of this class, I put, when you're dealing with a probate, you better know exactly what the attorney's up to, but please let your title rep know right away. We have great title reps, and they must be your third partner. Besides the attorney, your title rep is so huge. Over here, we use Pacific Coast. We also use a couple, Monaco. I'm sure you guys I know you guys use Pacific Coast over there, but you should basically take the listing and contact your title rep. Have them review the letters, have them review your listing, because the courts are very exact. I had one where we were in limited authority in the court, and the last name was Zimmerman with 2 M's and 2 N's, and the attorney had only put 1 M, and they threw it out, and we had to start all over again. It has to be exactly the way it's on the letters, because the court looks at that as we're notifying all the creditors on these names. So if it's misspelled, you're done. So working with title, if it's a conservatorship, is a whole different animal. They need doctors, certificates, 2 of them, they go to court. So don't get involved. This is not a class on conservatorship. This is a class on probate. Once again, it says right there, 90 days. And number 3, it asks you that you've already looked at the letters and which one is it, limited or full. So it's asking you again. And basically then it starts going into some MLS things and compensation. As I told you, 5 for limited. And you cannot arbitrate. This was here, this dispute resolution is completely deleted. It's very hard to get arbitration or mediation, because all probate is sold as is. You bought it, you knew what you're getting, it's done. There's no, this is why before limited authority, if you go to court, all your contingencies need to be removed. You can't have a request for repair or any reason that court's going to say, okay, come back in a week. Everything's got to be removed. If you win the overbid in the limited court, it's yours. They take that deposit check, and if you cancel, you lose your deposit. They're very tough on this because it takes so much long. So it's time frames. Basically, number 8 is very important. Notwithstanding any term in the listing to the contrary, seller warns that the title to the property is as follows, and that's where I put C letters. The biggest mistake I see, and I'm going to say it over and over, is that people do a prelim and it says just say Mary and Jane Hernandez, and you put that on your listing. That's what we're taught, right, on our regular listing agreements. However, you cannot do that on a probate. You must go to the letters. You must put the exact verbiage, exact, not misspelled. And as I said before, I had one where we actually had 6 names that we had to put on there, and we had to do an additional addendum to make sure all the letters were on there. The other form we're going to talk about is they used to have a probate purchase agreement, and they've eliminated that. Now they have a form called a PAPA, and you can make offers with a standard RPA, but you must let you have to have your seller sign this, and that this is telling you all what's going on to that buyer. And you must inform them, once again, if it's limited or full. So this buyer knows what he's getting into. Sometimes you get buyers who are very upset. It ties up in limited, ties up their money 6 to 8 weeks, and they've seen other properties that they want to make offers on, but they had to make a cashier's check and give that check to court. And I've had some very upset people saying, you tied up my $20,000 for 2.5 months and I didn't get it. You know, I could have made other offers. So this is what these forms are for. They're telling that buyer, like 2B or 3B, court confirmation, undetermined at time of offer. If you get it, you must notify it, set up a court date. If there's court confirmation, it's going to take a long time, and there's going to be an overbid, and you may not get that property. So this explains, once again, the court confirmation is required. It lets your buyer know what he's getting into. And then in here, before you can get to court, the seller may remove from the calendar if the buyer does not remove all contingencies. In other words, you've got your accepted offer is to remove all contingencies in 10 days. Now, court's a week away and he hasn't, he wants to negotiate, you can just cancel, say, nope, we're going in. Every contingency must be removed for us to get into that limited authority court. Now, once again, the contract, it says here, the RPA paragraphs, anything to do with guarantees or disclosures may not be provided, and that's what this is talking about, which paragraphs are going to be kicked out. On all forms, on all sides, whether you're doing a purchase or a listing, you must provide the probate advisory. And this, once again, is telling the seller that you may be exempt from certain guidelines because maybe the son who inherited has been living in New York for the last 15 years. The father sold the home they moved into and bought a condo, and the son's never even been there, or maybe was there for a day or two. So the heir cannot sign disclosures that he doesn't know about. So they're exempt. You know, there's exempt from some disclosures, and it'll tell you exactly what it is. They're not exempt. They're exempt from TDS, NHD, Melrose, and other stuff, earthquake, smoke detectors. However, smoke detectors always catches us because it says we don't have to do it. Yes, but the city does. So don't think you don't have to put smoke detectors or carbon monoxides on probates, because you will have to, because the city ordinance is stricter and that overrides. Plus, you don't want to get into a lawsuit where the house burned down and a baby died, and why didn't you put smoke detectors? So I put smoke detectors in all my listings, whether they're exempt or not. I just make sure it's done because I don't want that lawsuit. Basically, the probate in the sale, what's not exempt is you still have to do anything you know about the property and can discover. You know, basically, water heaters are not exempt. They must be attached and braced. You can sometimes, you know, sell a home as is. The home's going to be torn down, or an investor is going to gut it. You know, that's something that you can negotiate. But those are state mandates that you better make sure that it's very clearly written why he doesn't want a water heater strap, or he doesn't care about lead-based paint. But for the most part, they are not exempt. You still must put in a carbon monoxide. And of course, the taxes are always in there. brokers, just because the probate being sold as is and some of the forms are exempt, we are not exempt as a listing agent to do an avid. And we must go through and note everything we see, whether the seller wants to or not. As we know, that's a whole different class. The avid's very important. That protects us on what we see and what we have said. I got an excellent avid class. I worked with our attorneys a lot, and it talked about if a neighbor tells the buyer, oh, did you know about those dead bodies? And it was 5 years ago, how to disclose all that. So I'll be happy to give you a great avid example from our attorneys at Monica. But that's a different course for a different day, right? Remember that?
We have two questions.
Sure.
Ed, if you wouldn't mind me
Yeah,
sharing those.
no, not at all. I can't see the bottom, so that's why I haven't answered.
Oh, no worries. So the first question, which was backing up a little bit, but it was, does somebody need to keep the mortgage up to date, from Mario?
Absolutely, except there's also a special authority. There's 4 forms, 4 ways you can handle that. You know, obviously the daughter or whoever, I'm presuming, can get that mortgage paid right away. But there's on the letters of administration up here, we'll go back, there's also a box that says for special authority. Let me go back here, where it gives the, right here, you see this one that says special administration? That gives, if there's a problem with the mortgage, and let's say there's a foreclosure sale coming up in a week. Well, this isn't going to happen in a week, especially if it's limited. So the attorney can petition for what's called special administration, and that gets him to go to the trustee sale and try and stop the sale and tell him this is in probate. So there's different ways you should do it. But yes, if the estate has the money, absolutely keep the payments up. Sometimes the estate doesn't have the money. You know, the kids don't. You know, I mean, sometimes these house payments are $8,000 or $10,000 a month in the big estate, and the kids don't have that kind of money. So you better jump fast, and that's where you get your attorney involved. I keep emphasizing this is not a probate class for teaching you how to be an attorney. This is a class for you to show that you know what you're doing when you're listing or buying a property. But there's a whole bunch of stuff. I should have Paul Horn pay me, because I tell him his class is one of the best classes I've ever taken. He talks about the dollar amounts for each form and the time frames and what you do in special cases. So if you really want to dig in deep in probate, this is just an introductory class. I highly emphasize you take a probate class, and then you now become a probate expert, and you're going to have a million of those questions. So what's the second question?
The next, we've got a couple more that have jumped on, so I'm gonna go through them.
Fine.
The next
That's
one
fine.
is, your thoughts, probate and also foreclosure, is this doable, from Ralph? And you kind of touched on it just now.
I didn't understand the question. Probates?
If it's so my understanding, if it's a probate that is also in foreclosure.
Yeah. Well, there's 2 lead sources. So you can't say, you know, there's all kinds of services that you can attach. And, you know, I don't know your office, but, you know, some people use probate data. Some people use Paul Horns, but then some people use Property Radar for checking foreclosures. There's Rebo Gateway that'll give you sources. So it just depends on how you're chasing your leads. And, you know, a lot of people, we call probates, I like probates, you know, I do them. And it's just something, to me, it's called low-hanging fruit. And my experience has been, when you first approach them, they're always going to say, oh, we're going to keep the property. Yeah, and then you ask them, well, are you going to be partners with your brother and sister? Oh, I don't like them. And they start thinking about it. And a month later, when you know, I had one where I sold, and it was 5 kids, and they all hated each other. And the one, it was in Irvine, and the daughter who was in Irvine was handling the estate. And the daughter who was in Alaska is telling her, hey, send the car up to Alaska. And their other brother lived in Arizona. He's saying, oh, I want the piano and I want the safe. And the other sister lived in New York. Oh, and I want this and that. And she just said, wait. I'm not going to work for you guys unless you pay me. and I know you're not going to pay me, so this is the way it's coming. Next week, you guys all come down here and take what you want, then we're going to have an estate sale, and then the house is going. So I'm not going to do all this work for you. So there's one case in a probate when you're chasing them and you see 4 or 5 heirs, those are the ones you really go for. And you start looking for all the heirs, because there might be 5 kids and 4 of them are doctors and brain surgeons. And there's always that black sheep who studied art and he's living in his VW van. And now you get to him and he says, I want my money, like that commercial. I want my money now, So there's a strategy in working probates on a marketing, and I'll be happy to talk a lot more once we get into, if you guys want, we can do the probate data and Paul Horns, and he's got great marketing materials and postcards and all I'm impressed. I just went back on it a month ago and he's got everything you want to market probate. So that's something right there. Now on a foreclosure, like what we just said, if you're chasing foreclosures, what better way to say, hey, your house is in foreclosure, do you know that? And if one of the heirs say, I didn't know that, I was letting Susie handle that. Well, Susie ain't paying the bill. And he's going to be, wow, thank you, Monica. We're going to lose everything because Susie's so rich, she doesn't have time to work on it. So there's 2 angles to chase in this. And, it's called low-hanging fruit. I myself would much rather go after somebody I know there's a high probability they're going to sell. Probates is one of them. Because most brothers and sisters don't want to be co-owners in a home. And so they'll sell or buy each other out or do something, but it's called low-hanging fruit. We've all talked about those leads. So what else?
That's huge. I just got one that was they never went to probate and it's been 10 years, right? We get some crazy ones like that.
At the very beginning, I knew I blew through all that. I go, the way to sell a house through probate, and I put in capital legally, because some people just don't deal with it. And
they didn't realize, and they were paying the mortgage under the dead father's name.
Yeah. And because they can't assume it. That's all lending stuff. They can't assume it. And they never transfer the title because they always say, well, we don't need to. We're going to stay living here till we die, and then our kids can deal with it. Talk about a messed up estate. But I put in there, to transfer it legally, you go through probate. Now, you can sell the house, put the money into probate, and it still takes about 8 months after before the heirs get the money. So the home that IEA law gave the right to sell the home and then put that money into probate, and then it can be dispersed after all the heirs and creditors and all that. Sometimes the home dies. I actually know of a guy who he knew the guy next door and he died and there was no heirs. And so he just moved in. And he was at first innocently moving in to take care of the home and water and take care of it, expecting somebody to come and knock on his door and say, hey, you're in my dad's house. So he talked to his attorney, am I going to get arrested or not? And they said, no, but if you're smart, start paying the property tax. And so once you pay the property tax for 5 years, you can now do I believe, a tax sale and get the property. And he did. So there's a way to get a probate if nobody pops around. If not, it would have just gone back to the state. So he talked to some legal advice, and that's what I'm saying. This isn't how to buy properties through a tax lien. This is just your basic forms and stuff needed on what to do and what to ask for. Let's just finish up with a couple other forms.
You want me to share the last 2 questions, my friend?
Yeah, I'm here. I'm in no rush.
Perfect. I have, when working with the buyer on probate, should you also let them know about possible rate extensions?
Rate extensions?
Yes.
If you're working with a seller, or I don't understand the question. If you got a listing and you're trying to sell it, why do you care about the interest rate? You can tell them. Is that what I'm understanding?
With that one, if we could get a little bit more clarity, that would be great, and we can come back to that one. And then the next question is, how does having a reverse mortgage affect the probate sale?
Okay, reverse mortgages give you 1 year after the person dies to settle the estate. I've done a couple of reverse mortgages, and they understand that, you can't sell it until somebody passes. Reverse mortgages are very touchy in that if you're old and you go into a home, they've now considered it non-owner occupied. So this is what I tell back in lending. Be careful with the reverse mortgage because you may lose your tax step value and you'll have to sell it while the person's still alive, which could trigger a lot of capital gain. So the person has to be passed on before you, and I don't want to get into taxes, you can explain all that. But there's a thing when somebody dies in the state of California, I believe you have a $2 million estate to where you don't pay any taxes on. I think it might have gone up for $3 million. But that's a whole different tax course. Just make sure you tell the people the reverse mortgage will notify them immediately because they chase the notice of death, and they'll tell you got 1 year to sell this property. If not, the foreclosure proceedings start. So yes, they keep on top of it. What's that?
The next one says I have a friend that his father died about 3 years ago. It did not have a trust. One of the sons is living in it free and clear, doesn't pay anything. The friend.
Yeah, I told you there's always that.
Always the one.
Yeah.
Looks like another son wants to either sell the home or go to probate. What would be the next steps, I guess, in starting that proceeding? It looks like it hasn't. And then we have a raised hand next.
Yeah, I would definitely say to contact a good probate attorney, and he'll answer those questions. It's really hard to get somebody out of the house if they're an heir. So that's a great question for a professional probate attorney and maybe an eviction attorney. But that's something that is challenged all the time. And you don't want to take a listing and get it into escrow and then find out that brother's not moving. So you want to address all those things up front. I always recommend the property being vacant so that you can sell it as is and do your estate sales. However, if the kids are still living there, you better make sure the attorney knows that there's somebody living in there and he's got to deal with that. He may start a petition for unlawful detainer right away, but that's something that an attorney should answer and get involved in right away. What's next?
So this was a clarification on the buyer question, and then we'll go to the hand raise.
Yeah.
So the buyer question was, in the event, now the way I'm reading it is that if the agent is representing the buyer, sometimes because the probate time frame is so long from start to finish of submitting RPA, that sometimes they're canceling because the rates are changing, right? And they have to pay for the rate extension. Should they advise on the rate extension? And you tell me if I'm wrong, Ed, but I would think that would be the lender's responsibility.
Yeah, on probates, you don't want to get a short rate lock. You probably, if you're trying to close in 15 on a full authority, you should probably get a 60-day rate lock because you don't know if somebody's going to file a petition on that NLPA, proposed action. It's very rare, but I've seen it happen where you're going smooth and you take a 30-day escrow, and then somebody says, no, I just think it should go to overbid, and that's going to blow you from full authority to limited, and that's going to take at least 60 more days. And they can't, if it goes to full authority, you can do it fast. If it goes to limited, it's probably about a 90-day process. So there's, that person, if he's so rate sensitive, probably wouldn't be a good idea to get involved in a limited authority because you may not even get the property. So you may overbid it and take it from there.
I've got one last question and then we can jump back into the docs.
It's only 1:54, I got time.
Jennifer, would you like to come off mute?
Hey, Monica. Happy Tuesday, everybody. Hi, Ed. So I had just a question. So my brother reached out to me because he said one of his neighbors, he hasn't seen him for several months. The house had been vacant and it looked like there were some squatters there. I looked at the title and I saw that it had a reverse mortgage, but there was also a foreclosure date. So what advice would you have
The
to?
first advice, because it has a reverse mortgage, you obviously know they're older people. I'd call my title company and ask for any affidavit of deaths on that property. And if they say, yes, we have one filed, you know it's a probate. And at that point, try and get hold of whoever you can who's on title, or, you know, if you just ask the neighbors if they know anybody. Squatters are a problem. You know, they get in there, man, they're hard to get out, especially if they know the laws. I've had squatters where they actually get a driver's license in the address, and man, that's a full and lawful retainer action.
So is it a possibility, Ed, that the owner passed away and didn't
well,
have any
once
heirs?
again, if you call title and give them, you know, the name of who's on title and see if there's been any affidavit of deaths, that will tell you right away that yes, somebody passed. If there's no affidavit of deaths, then they might still be in conservatorship, or they may be in hospice. They may not even be cognizant to know that somebody's living in their home. That's when you do the best you could on people search, try and find heirs or sons, daughters. You know, I'm sure your office has different services. People search is one, if I remember, we were using, and it'll tell you, you know, where they lived and who else was attached to them, and start dialing for dollars, my friend, because it could be a nice little listing for you.
Sounds great. Thank you, Ed. I appreciate it.
Yeah, and I put my name on the front page. You know, feel free and call me anytime, because I love answering questions. And if you give me a question I don't know, then I love digging into it and finding it. So I invite questions that, you know, that stump me. I've been in this business. I was born with my real estate license. I'm 41 years ago, I got my license, and I've seen huge changes. And probates is just something that I had an investment company, and we're chasing them, and it works. You just don't. It's just like a regular listing. People are saying, you know, you want to sell? No, but you go back in a year, yeah, we're selling. And probate's time frame's shorter. Within 2 or 3 months, they already see that, you know, they'd rather just cash out on their inheritance and invest with their own family instead of being tied in with their brother or sister. So a good lead source.
Absolutely. Awesome. We could go back to the docs, and then if anybody else has questions, please drop them in the chat and we'll loop back around at the end. Okay, so most importantly, you have to have this probate advisory for either a listing or a purchase, and it's very clearly identified. The absolute thing you need on both the RCSD-S and -B for buyer or seller is you must have this representative capacity form signed exactly the way the court gives you the title. And remember I said, remember that case? Because right here, it says which case number it is. Now, the case number is something, like I said, if you're in a probate, the LA and Orange County has a website where you can put that case number in, and it'll give you itemized details of what's going on with that probate. That's where we found out the Zimmerman was missing an M and it got thrown out. The attorney was a work of art, and he was kept lying to us because he didn't want to tell us that he misspelled the name. So once we found that out, we called him out on that, and we kept moving forward. But on the RCSD, once again, you're going to say it's an estate, and you're going to want to put the exact names of all the people as per that letter and the case number. But you must have that to protect us. And basically, you know, here it says the time of listing. The case is when people don't take an RCSD, whether it's a trust or a probate or a corporation, and somebody just signs that. This is my experience as a broker. Somebody just signs your listing, and you say, oh, why are you signing, you know, as Ed when your dad's name was James? Oh, that's my father, I'm handling everything. So we have them sign this representative capacity to protect us as agents, that we just didn't have some guy sign a listing and throw it in the MLS. If somebody calls, and it happened, I told you my friend had it already in escrow when the sister called and said, why are you selling my dad's house? I'm the executive. That was a huge explosion, except what saved him was he had the RCSD signed, and that was proof that
he did his due diligence as an agent, and he represented his client with this letter. Had he not had this, he could have really been in some trouble and maybe even accused of fraud. So when this RCSD was made, it was to protect us on why are you signing somebody else's? And this is them saying, I asked, they signed, here's the signature. So that's what the most important thing on the RCSD is all about. Now at the very end, Paul gives you a time frame. I put it in here. Once again, the probate does not have to be closed to sell the home. So the attorneys are doing a ton of work before we get those letters. And this will kind of, run you through its legalese, and, it's more than what you need to know, but it'll tell you everything. And like I said, I can't emphasize a couple of good courses out there. Victor's industry, he was floating around a lot. I haven't seen him a lot, but he has a service called Probate Data. And he's also really upped his game on putting emails and telephones, because you want to sign up for a service where it just doesn't give you a name. Now you have to research all this stuff, spend hours and hours. So it's better to pay a little bit more, get the names of the attorneys, the phone number, the emails, and start a marketing campaign to attorneys. I had over 500 probate attorneys, not just attorneys. In Orange County, there's over close to 11,000 attorneys. You don't want a marketing campaign to that. So what I did is every time I got the CSV file, I take and cut the probate attorney out and put it into a probate marketing and start marketing it to that. In my experience with that, the larger firms, they blow you off because there's always somebody in the office. But the smaller mom and pop attorneys that talk to you, it's like getting a CPA who gives you leads, or a divorce attorney who gives you leads. So probate attorneys, you got to work them, but they're a good source. And then, they also, once again, the service gives you the phone numbers of the beneficiaries, so you can start calling. If not, you have to search. So anyway, the hour's up. I hope everybody enjoyed my little quick class. Once again, I'm not an attorney. Don't quote this. You can show it to people, but if they have any questions that's beyond your scope of duty, that's my big word to all my agents. Don't go outside your scope of duty. You're not an attorney. You're not a contractor. You're not a CPA. You don't give financial advice. We sell homes. And that's why CAR has put together these contracts to protect us. And we must know them and execute them fully. And it keeps us out of problems. We want to be selling homes, not tied up in court. And fortunately, like I said, my other offices, I don't know why. I guess there's more attorneys involved, but we get our issues over here. Anybody else? Questions?
Other questions that we have, my friends?
Okay.
No, well, a couple things. One, thank you so much, Ed. I could tell by the questions and just the thank yous in the comment that was really helpful. I think that this download, right? One of the things that I love, you guys, because I know some of you guys have seen Paul Horn and other different, probate classes. And I'm of the opinion that, as much as I want to know everything about a particular type of lead gen, I also want to know what's the practical application that I need as an agent, right? And that's one of the things that I loved about as I've been getting to know Ed and talking with Ed and some of the things that he's doing, is it's very much about, hey, here's the practical cheat sheet information that you need so that you can go out and actually take action on this, right? And we have some great resources as well for searching for this information. I'm gonna have our friends maybe share a little bit more of that on the team meeting on Thursday. A couple reminders. I know we have a few guests on the call. If you liked this class and you'd like to come out to some of our other classes, we'd absolutely love to have you. We also have upcoming the biggest real estate event of the year with over 50,000 attendees called Mega Camp. There's gonna be some phenomenal speakers, right? And these are people like Stephanie Vitaco, who did over 120 deals last year as a solo agent here in California, right?
Yeah,
We've got,
that's impressive.
she's phenomenal. You've got, you know, associates like Jeff Cohn, who was the #1 real estate agent at Berkshire Hathaway, had a team of 35 associates out in Omaha, and is now running KW Elite. And I'll note, I don't even think he was in the top 10 when he moved on over, right? You've got associates that are running teams that are doing to the tune of 1 million GCI, 9.9 million GCI, 10 million GCI, right? That are going to be really letting us under the hood of their business. And the nice thing is that for the first time, in order to attend this event, you don't have to go and fly to Texas. You don't have to pay for a hotel room, and every single row is a front row seat. If you're interested in finding out more, you can definitely shoot me a message or text message MegaCamp to 562-526-6668. Right, I threw it in the comment, and there's also going to be some freebies that we send you on a link that are available, including a copy of Shift, the book Shift, for those of you guys that don't have it, a copy of a couple other resources that we have, as well as this packet, right? But loop in, and we look forward to having you. And then also on our Eventbrite, we have CoStar and a commercial update on the market on Friday. So there's a lot of stuff on the calendar, but we'd absolutely love to have you, whether you're part of our brokerage or you'd like to join us as a guest on our next training. And I think it's safe to say we'll have Ed back for some more training, right? He did a phenomenal job. We love, I love the packet. Thank you so much, Ed, for sharing today.
Well, I put these packets together so you can keep them in your folder. And if somebody calls and says, I got a listing, but it's a probate, you pull it out and you're instantly an expert. You can learn everything else later, but go take that listing. We need to put gas in our cars. I want to thank you, Monica and Fred, for inviting me. If anybody has any questions, I'm an open arm broker. I answer my calls. Send me a PDF. I'll review it. If you have anything you want, feel free and call me. It's a pleasure, and thank you for everything.
Thank you. Thank you, everyone. Have an absolutely phenomenal rest of your day. Bye, guys.